number 73, Plymouth Venture Partners versus GTR Source and Capital Merchant Services. Counsel?
Good afternoon. May it please the court, Shane Heskin on behalf of plaintiffs' appellants. I'd respectfully request 3 minutes of rebuttal.
3 minutes, sir?
3 minutes.
You may have 3 minutes.
Thank you. There are 30,000 reasons why this court must answer the certified questions yes. That is the number of judgments that the MCAs have amassed in this court system. Unfortunately, that number is only growing through default judgments even today, even after the legislature stopped the confessions of judgment. What happened here is a rogue New York City marshal reached across state lines in Michigan, froze a bank account, causing an avalanche of adverse effects, missing payroll, defaulting on other lenders, and getting put into a receivership. It cannot
So, I'm
be-
sorry, counsel here, sorry.
Sure.
At that time, when the bank account was frozen, as I recollect, the debtor went into the court and tried to get the judgment reversed, right? Why isn't the proper thing to do then, at the same time, to seek to get this execution undone? Why do we wait all these years, and now we have a federal action, and now do we have damages? Do we have a marshal involved? When it all could have been taken care of then?
Well, there are a couple of reasons. One is there didn't need to be a void to vacate the judgment or the levy at that time. First of all, what they did, the first efforts were to try and vacate it on a couple procedural grounds, which was they didn't file it in the county. The second was under BCL 1314, where we're trying to get the judgment vacated altogether. It's very expensive and time-consuming to have to file a plenary action, which the court would have required. Is you have to file a plenary action, you have to litigate it on the merits and overturn on the usury. It's a very fact-intensive process. That's expensive. You're talking about...
But why couldn't they come in on an Article 52 and say this is an improper attachment? They had notice, they had the time. Come in and say it's an improper attachment. Why not?
They could have, but didn't need to. So
Why? Because we'd rather, as a policy matter, have this?
Well, as a matter of public policy, you shouldn't, a debtor in California who had their bank accounts attached and seized by a New York City marshal shouldn't have to come to New York to...
But they're subject to jurisdiction. The judgment is in New York. So why shouldn't they have to come to New York?
Because the process is void from inception. It's not necessary.
But that seems like a non-sequitur. So they have a valid judgment in New York. They're subject to jurisdiction in New York court. They get notice one of their bank accounts is attached. They come to New York and they say you shouldn't have attached this. I mean, they could bring a federal action years later, you know, in a district court, but that seems a little less convenient and efficient.
It's not what's required under the statute. And for example, look what happened in Silver Cup, okay? Silver Cup we did exactly that. And there's a big distinction there because in Silver Cup, the marshal acted within his authority. He served it within...
Article 52 case?
Silver Cup was in Article 52, yeah.
Right.
So he served it within New York City. So there, he had the jurisdiction, he had the authority to issue it. So that's what brings it within Article 52. Now, we got that vacated, but we were then required to seek a plenary action to get damages for that. So it's not something that's economically feasible by just going in New York and getting that modified, because now we can bring a plenary action. We don't have to bring it in upstate New York. We can bring it in federal court. It's not required. So that's the distinction between void and voidable. Where the marshal acts within his jurisdiction, then yes, we have to go to Article 52 applies. We have to go to that court and get it vacated, and then we seek a plenary action.
But counsel, I mean, that's clearly not the case. The assets were levied upon, the bank released those assets to the judgment creditor. To make a distinction between void and voidable seems somewhat incongruous, given the fact that the proceeds actually made it to the judgment creditor. And I think the question here is, why wasn't there an effort to void the encumbrance?
Because there was an action brought, and common law allows you to bring an action for wrongful execution. It's a void process. We don't have, what you have to understand is that in these confessions of judgment, they authorize judgment to be entered anywhere in New York, in any county in New York.
I thought it was 2 counties.
No. So maybe today, but prior, it said it had to be
So
entered
should we have a
in.
different rule if it's a case like this and it's a judgment creditor that we find particularly offensive? We have a rule, but if it's a different judgment, we have a different rule?
No, that's not the
So
case
what
at
do the
all.
facts matter in that sense? Like, what does it matter that this was a confession of judgment or that it was this type of loan? Because if we make a rule, it's going to apply to every case.
Sure. And the key here is that Article 52 simply does not apply. It's not efficient. It's a void process. And the judgment, the victim has the right to go anywhere, any court they want to get the relief because it's void.
Will you help me with the record a little bit? I thought, at least as to GTR, there was a motion made by you under 5240. Is that wrong?
That is wrong. That is not correct. We didn't do it under 52 in the state court. We did that in Silver Cup. In Silver Cup, we did a motion for 52. In GTR, we did 2 things. We sought to vacate it because of the county issue. They filed it in the wrong, one of 62 counties. And then BCL
I thought
1314.
before the receiver became involved, there was actually a motion made in front of Supreme Court on 5240.
It was only to vacate the judgment, and then upon vacating the judgment, it was for restitution, is to turn over the funds. And that motion procedurally was denied. So then, after that was procedurally denied, we filed it in federal court on the wrongful execution claim. And that is, the difference is that if we had to vacate the judgment up in New York first, which we don't have to do because the process was void from its inception, and that's the key distinction, is that if you, once the marshal acts outside of his jurisdiction, that is void. It never happened, and he therefore didn't have authority. Once he served something in Michigan.
So that means that, so that's your response to that there was not a tort here at all. In other words, your void versus voidable argument is the basis for you rejecting GTR's argument that this is a valid money judgment, and even if the service was improper, it's irrelevant since it's a valid money judgment, and you're not entitled to any damages beyond those damages, so there really wasn't a tort at all here to begin with.
Well, there is. There's definitely a tort. There are definitely
Well,
damages.
all right. It seems to me, if you have a valid money judgment, then that's the damages that you're entitled to. And for there to be a tort, you would have to show us something beyond that money judgment for damages. There'd have to be established proximate cause and show that there are some other damages beyond this money judgment, and I don't see those in the tort that's pled.
Well, there was money in the account, and now there wasn't money in the account. So they took the money in the account. And think about how this would play out in this case.
Well, let's just stay with my tort argument, all
Sure.
right? What I'm interested in is the fundamental question here is there a tort? And so we got a duty, a breach of a duty, a negligent action. Let's give you all those. I think it's a fair argument. Then we say, what are the damages, and is there proximate cause establishing those damages? Well, if we apply the but-for principle and proximate cause, it's pretty hard to show that you have anything beyond a money judgment as damages. So therefore, if the money judgment is valid, you have no cognizable damages.
We do. It's simply the money that was taken out of the account. And then you'd get into
So in
the
other
issue
words, the
of-
money
of
judgment, the execution of the money judgment is your damages.
The money they took out of the account.
But
I had
if the
30,000
judgment is valid to begin with, it doesn't matter because it's the same dollar amount. There is no tort.
Well, then you have to apply the concepts of offset. And offsets are equitable. You cannot take your own, take money illegally and then apply it to your own judgment. We've
So
cited,
I understood your argument. Honestly, I wasn't as impressed by that argument. The one I was struggling with was whether or not there was an actual tort here. And if so, how does this play out if there aren't any ascertainable damages beyond the valid money judgment?
let's just play out how this would work if the money was returned. If the money was returned back to,
Well, why don't you start that a little differently? If it had never been taken, start it that way.
if it had never been taken, my client would have had the money to make payroll. He wouldn't have had, he would have been able to use that money to pay senior secured creditors.
So you had a senior secured that was 5 million or so, is that right?
Exactly. And so the money would have been paid to them. And so what this rule is creating, if you allow this to go on, it's going
But
to
counsel,
encourage-
if I can interrupt you on that damages, I'm on the screen, excuse me.
Sure.
Doesn't that go to damages for a different party, not for you? Those are damages to the senior lenders?
Well, not necessarily.
That's what I'm not understanding about.
Sure.
I don't disagree with your point that it does sound like someone's jumping the queue on the creditors. I'm not going to disagree with you there. But the question is whether or not that's a tort that your client can pursue.
Sure. Well,
Damages to them.
there are a lot of consequential damages that occur from that. One is if you take the money by violating the law and I can't make payroll, I'm going to have payroll damages. There are going to be fines for that. Then also, if I had that money and I could have paid my senior secured creditors, I now have, it's like a preference payment. I now can choose how I use that money to pay off. I'd rather pay someone where that's got a senior secured lien on all of my property than pay
So
someone.
if I'm understanding your argument, I don't know that this is the way you actually litigated the case, but if I'm understanding your argument, you're saying if the law had been followed, there are particular payments that you would not have incurred. And those are the ones that you want reimbursed, not necessarily the debt itself.
I
Am I
don't want the
understanding
debt-
correctly?
Yeah, correct. I don't want the debt itself to be paid. I want, if they took $300,000 out of my bank account, the $300,000 goes back into the bank account, and now we're in a receivership, and that would get distributed in order of preference. The creditors that didn't break the law would get paid first in order of their
Yeah,
preference.
but again, you're saying that the damages you actually suffered from that had to do with these fines related to payroll, or am I misunderstanding?
It's a combination. I'm saying, I'm giving you hypothetical consequences of
Yes.
what the damages could be in any particular case when you follow this rule.
Yeah, well, are those damages you asserted?
Are they, yes, we are asserting consequential damages in these cases. And so we missed payroll, we were put in a receivership, we were not able to make payments to.
So let me ask this, if they had followed, if they had followed the law, or if it had properly been executed, and the bank turns over that money anyway, wouldn't you have been in the same place, unable to meet payroll? I mean, that's the whole point, you don't have the money to pay your debts.
Well, if they had followed the law, we would
Yeah.
have had notice of it. They would have
Yeah.
had to come to Michigan and properly, and we could have sought injunctive relief and would have been on notice, rather than just having a marshal seize
Yeah,
their.
but notice that you owe the money, you haven't paid, and you got to turn it over, and they're taking it from your bank account? Again, I'm not really, it'll be the last question I ask along this line. I'm a little bit confused as to how, at the end, you're put in a worse position. I was looking for that part of the damages.
Well, at the end, if this did, but for the unlawful activity, my client would have had the money, would have been able to make payroll, and it would have been able to put in, pay its senior secured creditors. If they had followed the law, all those things would have happened. But because they did not follow the law, they woke up one morning and found their bank account frozen, they missed their payroll, they were defaulted on their senior secured creditors, and there were other consequences.
Counsel, does the bank bear any responsibility in this tort? As you say, it was a judgment void ab initio. That should have been as obvious to the bank as it was to anyone else in this transaction. What's their responsibility for turning the funds over?
There are banks that will not honor these, and there are banks that just don't want to get involved. There's no liability on the banks. They have provisions in the contracts that say if we're served with a subpoena or a levy, we have the right to honor it, whether it's valid or invalid. So they don't want to expend the resources and attorney time to actually have to try and figure that out or litigate that. So they can turn the money over, and that's typically in anyone's bank account.
Thank you, counsel. Counsel?
Thank you. Good afternoon. Ryan Cummings on behalf of GTR Source LLC. To please the court. Your honors have already touched upon the primary issue in this case, which is there's a valid judgment here. It's been litigated twice, and it's a valid judgment. So we have a valid judgment. Where we depart from the appellants here is what happens if you go and try to enforce a valid judgment as opposed to an invalid judgment, and you happen to make a mistake under Article 52? What are the consequences?
It may be a little different from that.
Okay.
Because there is the Uniform Enforcement of Foreign Judgment Act, right? And that's been adopted by almost every state, including Michigan and New York. And at least my reading of it is what you should have done once you had the valid, and I assume the judgment is valid. The Second Circuit asked us to assume it's valid, so you don't have to argue that. If you have a valid judgment here, you have to walk it over to a Michigan court, register it there, and then levy on it there, especially when you're dealing with a third-party garnishee, a bank that has no presence here. So the question really is the last one, I think, that we were dealing with, which is, suppose that's what you had to do. And suppose and you don't have to concede this, just suppose for the purpose of my argument or my hypothetical, that the marshal had no jurisdiction to attach this property in that way. You have to go through the Uniform Act and register in the Michigan court, and you didn't do that. The question, though, is what would have been different, right, had you done that? And the thing that I think we may be missing a little bit is we're being asked for a rule from the Second Circuit. And it's a rule that has to apply whether we're talking about a $150,000 judgment or a $5 million judgment, and a secured creditor in a first position who maybe should have notice of this, and procedures that are available such as bankruptcy and restructuring. We don't have to, this company, for a variety of reasons, looks like it was not going anywhere, right? But we have to consider the situation where it might be a company where you could negotiate with the first lien holder, part of the lender in the first security position, who might want a going business and might be able to work something out. So the question is, can we be sure on the first question, I'm not at the second question, the first question from the Second Circuit, that in all cases, the fact that all you're doing is executing a valid judgment through an improper means, and assume it's improper, you can tell me why it's not if you want, is that always going to be a case where you can't bring a tort action? That's the question.
And the answer is no, you should not be able to bring a tort action in that circumstance, that hypothetical that you just laid it. Ever. Because actually Article 52 provides a mechanism for an expedited resolution of who's entitled to...
Well, that's the second question. So suppose Article 52 didn't exist, you'd have a tort action.
You might have a tort action if the improper execution was done maliciously, intentionally, something like that, where it's a simple mistake. The courts in New York have said, look, we're not endorsing this, but you're not liable in tort. And in this particular circumstance where you have a marshal, it is not as if there is not oversight.
Well, negligence is ordinarily thought of as encompassing simple mistakes. Right, I mean, trespass to chattels works whether you're negligent or you're intentional or venal.
Actually, trespass to chattels actually does have a bit of an intent component. I just happened to finish a trial on that very issue. And it's an intentional interference with somebody else's superior
You
possessory
have to know that
interest.
it's their property, yeah.
Yes, yes. So those circumstances are slightly different than what we're talking about here, which is technical noncompliance with an enforcement statute. And there is an avenue. Article 52 does exist. There is an avenue for a judgment, somebody who believes have a superior interest in that property, to come to court expeditiously within 7 days and get a determination as to who's got priority over those dollars or that property. So we do have a mechanism here. And council has touched upon, is it void versus voidable? And the question was asked, well, what does Comerica Bank do in this circumstance? Because Comerica is actually the one who receives the execution and is in a position to say, wait a second, we're not subject to personal jurisdiction for some reason in New York, or this isn't properly issued to us. That was a right that Comerica had.
Well, but wouldn't the damages be limited to the value of the property that was the subject of the money judgment only? And in that circumstance, you wouldn't have a valid tort. But there can be circumstances where you may have a valid tort if there were different damages.
There may be a hypothetical
So,
situation here.
I mean, one thing I've learned in my grind through the legal system is the variety of damages is pretty much limitless, right? I think we'd all acknowledge that. So that being the case, they may not be in this circumstance because your damages here may be limited to a valid money judgment. But any rule that we make may need to be limited to the value of the property that was the subject of the valid money judgment only. Because anything beyond that would create a rule that would restrict tort rights that they may or may not have. And it may be that fraud, you may be in a fraud territory, you may be in ordinary negligence, but it's irrelevant for us to even reach that if we limit it to the damages that are subject to a valid judgment.
I agree with you, Your Honor. That rule seems to be narrowly tailored to the circumstances that are before the court in this
So
particular
would you be advocating a limitation like that in any response that we gave to the Second Circuit?
I think that's the issue before this court, and that would make sense to limit the response in that circumstance to this issue that has been litigated before both the Second Circuit and here.
Thank you.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Christopher Murray, Stein Adler, Daba, and Zelkowitz for the respondent, Capital Merchant Services. Your Honors, there's kind of a key factor here. Counsel has argued repeatedly that the way this case is distinguishable from Silver Cup is whether or not the service actually took place in the jurisdiction where the officer it's their county, their locale. In Capital Merchant Services case, the service took place in Rockland County by the Rockland County Sheriff's Office. He's arguing that the Comerica Bank was simply served incorrectly, but it raised no objections. That's relevant for a lot of reasons. One is that the objection would belong to Comerica Bank, and Comerica Bank has never raised that objection. It has never objected to jurisdiction or service. And in that regard, this is a lot like Kohler versus Bank of Bermuda, where if you have jurisdiction over the garnishee, because the garnishee is not objecting, and you have jurisdiction over the judgment debtor, because you have a judgment against them, there's really no issue. It doesn't matter where the property is, because you have jurisdiction over whoever it is that you need. It is based upon an in personam jurisdiction, not based upon in rem. It doesn't matter where the accounts allegedly are. So that's a key factor. Additionally, the duty that they allege was breached is not a duty that is owed to the judgment debtor. It is a duty that belongs to the bank. We didn't breach any duty to the judgment debtor. The judgment debtor is entitled to no protection based upon whether or not the bank is properly served. They suffer no injury.
Why isn't the judgment debtor entitled to protections of Michigan's enactment of the uniform law?
Respectfully, Your Honor, it's because the judgment debtor is subject to New York jurisdiction as a judgment debtor. They consented to jurisdiction here. They are subject to our jurisdiction.
Isn't it clear, though, that if their assets are not located in the state, you have to go through the Uniform Act and you have to register in Michigan?
Absolutely not, Your Honor. That is not the law. The law in Kohler versus Bank of Bermuda and in the vast majority of cases in New York is that if you have jurisdiction over the judgment debtor, you can go ahead and get your relief from the judgment debtor here. Now, if there was real property, that is actually an exception to that rule. However, in this instance, we absolutely can go after their assets because they are subject to jurisdiction here. The judgments are enforceable. That's the key fact. The case law that counsel cites where there is a void versus voidable distinction all arise from the alleged judgment being in some way defective. There's a lack of subject matter jurisdiction from the judgment. The judgment had already been satisfied. The judgment had already been vacated. The underlying debt had already been satisfied. None of that is applicable here. The judgment was enforceable. Thus, the issuance of process, the execution, was valid. Counsel's objection is not to the issuance of process. That, I think, is settled law, that the process itself is proper. His objection truly is narrowly tailored to the execution in service. He's saying that service of process thereby renders the initial issuance of an execution improper. Respectfully, that is not the law. And we cite case law to this effect within our brief, that essentially it all hinges upon the objections that it all hinges upon this.
So, just so I'm clear, are you saying that the only issue to be decided is whether or not there is a valid judgment, and the means of enforcement, whether you domesticate a foreign judgment or where you serve it or who serves it, are beside the point?
Your Honor, I would say they're beside the point as long as the issue that is allegedly technically defective that they're arguing is a protection to the non-party garnishee. If the bank had objected in this case, they would say they have no damages because nothing would have happened. Their argument is that the bank consented to jurisdiction and therefore they have damages. That can't possibly be the basis of a bright line rule, that if the bank consents to New York jurisdiction, now they have a tort claim against us. Respectfully, that's not reasonable. Now, the reason counsel is bringing this as a tort claim, he makes that clear in his reply papers. He wants it to be a tort claim because he wants to sue attorneys, collections attorneys. He wants them to be alleged joint tortfeasors. That's the reality here.
Can I just ask you, as a point of personal confusion, is this enforcement tort a negligence-based tort or an intentional tort, as far as it exists out there in the world?
Your Honor, I understand it to be, he's arguing that it's something of an intentional tort.
Okay. I'm sorry, it's not clear. We talk about duties, breach, causation, negligence, reasonable people, and I begin to think that it's negligence sometimes.
Understandable. There is one last thing I did want to say. Counsel has argued about there being a senior secured creditor. There's never been any adjudication about any senior secured creditors at all. This transfer of the claim took place in the Second Circuit after the adjudication had taken place in the trial court. To that end, the idea that there is some sort of a difference in standing that he's arguing or that he's allowed to assert an injury to the senior secured creditor, it's not correct. And more importantly, the reason why the senior secured creditors has not brought any claim is that they're not actually senior or secured as to money in a bank account. Money in a bank account is not secured by the filing of a UCC-1. It's secured by control over the bank account. And those creditors never had control over the bank account. And that's why they haven't actually challenged it, because as far as the money is concerned, they are wholly unsecured. They are, in fact, beneath us in terms of the order of priority.
Thank you, counsel. Counsel?
Thank you, Your Honor. I'll try to be as brief as possible because I know we're all on the same side here. Andrew Shriver from Cuddy and Fader on behalf of Marshall Beagle. I do want to sort of bring us back to the beginning of the issue that was presented by the Second Circuit. The key phrase was whether or not the judgment debtor suffers cognizable damages. Cognizable. I looked it up in the dictionary yesterday. Not part of the record, but common sense. That means capable of being known, right? What is the injury? We talked about it a little bit. I heard it from the bench. There is no injury here. And to the question as to whether or not, even without Article 52, this would sound in tort, the answer is no, for a very, very, very basic reason. Under New York law and pretty much every other state that I know of, you need to prove each element of your claim in order to stay in court, right? Here, let's assume for the sake of discussion, as Your Honor had pointed out, that there was liability or possibly liability on the first prong. Without proximate cause and an actual injury to the person who's bringing the claim, you don't have a case.
Right, but we are just, I think, and correct me if you think I'm wrong, the Second Circuit is just asking us about the damages element. They're asking us to assume the rest.
Yeah.
And they're saying, is the fact that you took the money and used it to satisfy a valid debt,
Right.
is there any circumstance where that might cause damages recoverable in tort?
Okay, and so
And
the
I understand why it might
yeah.
not in this.
Yeah.
And I certainly appreciate in this case, if I were the plaintiff's lawyer, I would have a tremendously difficult time proving what those damages were. My question is that always going to be the case? Is
I
it
think
always going to be not cognizable?
The answer to that, Your Honor, I think is yes. It will always be the case for one reason. If it's subject to a valid judgment and the debtor is the one who's bringing the claim, the theory that was advanced by counsel was, well, it was the debtor's money. It would have been in the account. We could have made payroll with it. But as a matter of judgment enforcement policy, once there's a judgment against you, the only assets that you have that are protected are those that are protected by statute, exempt under the law. Other than that, what's sitting in your account is subject to reach by any creditor. It's whoever gets there first with a validly issued levy. So the concept that I was injured because I couldn't make payroll, that injury was not because the marshal executed a levy. We all know that, but for the procedural objection,
So
any
had-
marshal could have done it correctly. But just to
Right.
finish the point, Your Honor,
So-
yeah, go ahead,
Had you
please.
gone to investigate...
You see where I was going, yeah.
Had they gone to Michigan,
Mm-hmm.
right, and domesticated the judgment, and then there's a 21-day notice period.
Sure.
Presumably, Detroit could have put them into receivership.
It could have happened. There could have been a bunch of different types of remedies,
and
all of
then-
which would have been the equivalent of what you could have done under Article CPLR 5240, right? But that's the absurdity of this all. The theory of their case, as alleged in the complaint, is somehow the marshal should be liable for a judgment. And as you said, this is for a $127,000 case. It could be for a $10 million case. And if we start getting into whether it was intentional or not only are we stepping on the toes of the appellate division authority pursuant to the Civil Court Act, Section 1610 and
Well,
1612.
the marshal may have other defenses that are not at issue here, no?
Including quasi-immunity as a public official, which we didn't get into, but it was just raised, so I want to point that out before we start, pointing the direction of that. But the biggest problem that the debtor faces in these situations is absent any other actual damage. There is no damage and therefore no claim. I'll give you a perfect example. There is a case cited, I don't have it in my memory right now, but I was reading it last night again, and there was a case where the court had said, well, the marshal in executing a valid levy was removing things from like a washing machine, a laundromat, and in that situation, the marshal damaged property, right? And even there, the court said, well, okay, maybe there's something for damages there, right? Not anything like our situation. But then the court said, but that's why there's a statutory remedy for why there's a bond required for the marshal, because you can make an application against the bond. In other words, every direction we turn in this case, at least insofar as my client is concerned, there's a statutory remedy, and there is officially sanctioned and statutorily prescribed oversight by the Department of Investigation, which in this case was contacted, did take a measure by issuing a memorandum warning, and we know under 1610 and 1612 that both the Appellate Division and the Department of Investigations have a non-delegable discretionary power to say, we're going to suspend you, we're going to remove you, and in certain circumstances, we're going to take away your badge. And where we get into the Cruz case that this court decided on similar facts when it was certified by the Second Circuit, this court properly said, why are we going there where there's already a statutory remedy under Article 52 and there's no clear evidence of legislative intent to create a private cause of action? And in this particular circumstance, we know that that was not a legislative intent because the statute specifically allows for a procedure whereby the actual...
But there I think you're missing something, because we're being asked to assume that there is a tort action. The Second Circuit's asked us to assume that. They're not asking us to create a private right of action. So we're not in that world. We're not in the create a private right of action world.
Yeah.
We're really asking whether the CPLR has supplanted, this is the second question, supplanted a tort remedy that might otherwise exist.
And I think the answer to that clearly is yes, Your Honor.
Why?
For one basic reason. Because you're dealing with a legislative scheme. I believe that it's the policy of the court in this state, and most courts in most states, is that where the legislature has, and you've talked about this at length in Cruz, you said the most important factor as to whether or not a private right of action can coexist.
That's implying a private right. We're talking about something different. We're now, assume the answer to the first question is yes. Just
Okay.
for the second, just right, that imagine that's yes. It may well be no, but imagine it's yes, right? If there is a tort action, then we're asking a different question. We're not asking about whether the legislature intended to create one. We're asking whether the legislature and the CPLR intended to eliminate the common law. And that's a very different question under our jurisprudence.
So, Your Honor, I don't believe that it did intend to eliminate the common law. And the reason I can say that with some degree of confidence is because there is recognition in the Silver Cup case, by way of example, where after the thing they're complaining about, right? If they had gone under Article 52, vacated, set aside the levy, reset the clock, so to speak, I still don't think the debtor would get the money. It just means some other creditor would get it. But that's step one.
Can I
Yeah.
ask this, because this is an important point that the judge asked. The way I understand the question that's being put to us is, was there a tort violated here, which is the same thing like as saying, was there a tort at all?
Right.
Right. And in the absence of damages, how can there be a tort? That's your argument, right?
Precisely.
So we don't get to the second question then. But the question that Judge Wilson, if I understand it correctly, is that may be true in this circumstance, but it can't be true in every conceivable circumstance, right?
So it's conceivable, and this goes to the colloquy I think you were having with my colleague a bit. It is conceivable, and I suppose this is why I go back to the case where, for example, the marshal damages the washer, right? In that situation, that was sloppy, that was negligent, there was property damage, it was not within the scope of the marshal's
I
duties to
understand that
do
there
that.
may be statutory remedies that supplant the common law remedies.
Right.
But there still may be circumstances that we have not conceived of.
Yes.
Where damages could arise in a tort like this.
So I would suggest that the court tread very carefully when it comes to the marshal, because there is such a widespread statutory regime. If we're talking generally about judgment creditors, if during the course of any judgment enforcement, rights beyond those rights that a judgment creditor would have get violated, and the judgment debtor can show something other than, well, this money that I owed pursuant to a judgment, that's not the damage. But if they say, and in addition to that, I lost X, Y, and Z.
I don't think courts have to answer these questions if they aren't necessarily in front of them. We just have to make sure that we don't answer this one in such a way that it precludes the possibility of the next one.
I suppose, Your Honor, that if, careful jurisprudence would warrant the court suggesting that this case may not be all-inclusive, but I certainly would be careful about language that might encourage others to try the same thing. I think that the case you're looking for simply has to wind its way up on those facts. And I agree with Your Honor, it is conceivable, but this case is not the poster child for making a change in law.
I see.
Thank you, counsel.
Thank you.
Thank you.
Counsel, your rebuttal?
Thank you. First, real quick, on the issue of damages, there's clear damages on the poundage fees. The marshal charged poundage fees in addition. So at a minimum, there are damages there for the poundage fees. And he charged poundage fees by exceeding his authority, by levying outside of his jurisdiction. So you
I'm sorry,
absolutely-
weren't the poundage fees payable by the judgment creditor?
No, they were taken out of the account. We were responsible for those
In
damages.
excess of the judgment amount?
Yes, absolutely. So at a minimum, there are damages at a minimum for the poundage fees. We had to pay for those. So
I'm a little confused. I'm sorry. I've got to follow up on the poundage. I'm on the screen. I thought, at least in one of the cases, there's actual satisfaction of the debt. So you're not being charged for the poundage fees, or did I misunderstand the record?
the poundage fees are added to the levy, yes. If you look at the levy that's in the record, it actually has the poundage fees that are charged, and they're deducted from the account. So those poundage fees are absolutely damages. At a minimum, those are damages that have to be addressed by this court. But think of the rule that this court would send as a matter of public policy. You heard it right here. Whoever gets there first. Whoever gets there first. That's the rule they want you to create, whether lawfully or unlawfully. Reward whoever
But why couldn't the
gets
rule
there
we create
first.
be, stop them from getting there first, so going in Article 52, which is your exclusive remedy here? Why isn't that a bad rule? And then we don't need to answer the first question.
Well, because Article 52 is not exclusive. It's been the common law.
But it's not exclusive, maybe an open question right now, but it could be, depending on the answer we give to question 2. So why would that be a bad rule?
Because it would require multiple steps, Your Honor. For example, just look at what happened in Silvercup.
But you were in there, you were in court, you took this step to challenge the judgment at a time when this was, as I understand it, being executed, and you had notice of that. So what is the extra step? This is an extra step. To bring a federal case against all these people and wind up here is a lot of extra steps. What is the policy reason that we wouldn't want judgment debtors with a valid judgment to go in under Article 52 rather than do this?
Because it's, first of all, Article 52 did not abrogate the common law of
No,
wrongful
but
execution.
that's not my question.
And-
We'll decide that,
Sure.
but why, what is the policy reason for not doing that?
Because a judgment debtor should be able to go into the court of its choosing and pick its
Not if
form.
there's a judgment against it in a court in New York. I mean, that's kind of been answered already, and you have a valid judgment here. So I'm still trying hard to understand why, as a policy matter, we would want this, when if Article 52 is exclusive, and you had notice here, and you could have gone in, you would have avoided this if you were right.
Why would my client, let's say he's in California or Texas or wherever, and if they committed a tort in New York, it's wrongful execution, and they caused their damages, why should I have to come to New York to travel and file
Because
an
you've
action?
conceded to jurisdiction in New York by your confession of judgment, and you have a valid judgment here. It's not like they're hauling you in here, and you said something before, they woke up one morning and the money was gone. Not really. I mean, they had notice it was attached.
I understand, well, actually, the confessions of judgment don't give you notice. They file, this is how it happened, or at least this is how it did happen in the past, is they would file a confession of judgment, and within minutes, they would give it to the marshal, and your bank account would be frozen. So you would have
But you have
absolutely no notice
noticed that the bank
whatsoever.
account is frozen. You had it here. And you had the opportunity to go in, and in fact, went in, you just challenged the judgment, not the execution. So why wouldn't a good rule be, if you're going to do that, and you're coming into New York anyway to do that, why wouldn't the rule be that the exclusive remedy here, rather than try to prove a 140-year-old possible tort, is to go in there and say the attachment's not valid? And then that court can order it released. No poundage fees, no payroll issues.
It's because if I'm in California, I can do it in California. It's more convenient for me. If my rights have been violated in California, and you've got to remember that these are predatory loans, high-interest loans.
But this rule is for everyone.
May I try a little different version of Judge Garcia's question that is actually, the Second Circuit hasn't asked whether you can't bring a tort action. They've asked whether you have to go under 5240 first, right? So why, I think that makes Judge Garcia's position a little stronger if you think of it that way. That is, suppose you do have a tort action, but the rule is going to be the first thing you have to do is try under 5240. Failing that, we'll leave it for another day whether you can proceed under tort. Why is that a bad policy?
Okay. Well, first of all, Article 52 would have to apply, and it would only apply if there was jurisdiction to issue the levy in the first place. So in the circumstance where
You would go on, wouldn't you go on 52 and say there's no jurisdiction to issue the levy, vacate it?
you could, but the marshal, you don't have to if it's void. It's as though it never happened. If the marshal exceeds his authority.
No, but counsel, I'm sorry to interrupt you. If I'm understanding this line of questioning, the point is you have to go into a court to get a judge to say that.
Correct.
And the question is, why not use what is already available to you? Judge Garcia is saying, you already went part of the way, used part of Article 52. Why not go all the way? And Judge Wilson is saying, well, there's a question as to why not start there, and if there's a deficiency in that process, perhaps you got a tort action. And may I just mention, you keep talking about California. In this case, you actually did come to New York. I mean, you're in the District Court of New York, so I'm not really sure I'm understanding fully that argument.
Well, let me just.
I mean, some judges got to decide what you claim you want decided, that it's void versus voidable, right? Some judge, some court has got to make that decision. So you're going to have to subject yourself to the jurisdiction of the court for that.
Correct. And under the law, we're entitled to choose that form, whether it's California, whether it's the Southern District of New York, whether we want to go to Broome County or Orange County or wherever. We have that option. We shouldn't be forced into going to a court that is chosen by the happenstance of the judgment creditor. And that's what's happened here, is we have the opportunity. For example, in Silver Cup, it's in Ontario. My client is in New Jersey. Why would I have to go all the way up into Ontario County to litigate it when my client is in New Jersey? It would be much more convenient to litigate this in the Southern District of New York or to litigate it in New Jersey. But because of the way these jurisdictional disputes, they can be in anywhere, any county in New York, and it's picked by the judgment creditor. And so we should have the opportunity to say, listen, I don't want to have to go all the way up to Erie County to fight this. I don't want to have to go to Broome County. I can pick my battle in the Southern District of New York. That
Counsel,
option is always available.
is there anything in the certified question or in the argument that you're making that limits this tort to foreign judgment debtors only? And the question I'm asking is, what's to stop a domestic judgment debtor from bringing the same tort action for wrongful enforcement of the judgment? I know your client has a particular hardship, but is there anything about this that limits it just to foreign judgments?
No, it could be a domestic one too. If, for example, the city marshal were to execute on a bank account or issue a levy in Erie County, then they would be able to bring the same thing.
So any judgment debtor who's unhappy with the way the judgment was enforced conceivably has the right to bring this action for improper enforcement?
Yes, if they broke the law. Think of the rule that if your honors answer no to this question, either one of these questions, Marshal Beagle and all the other New York City marshals can go out there and issue levies anywhere in the country without consequence. Without consequence. Why wouldn't they do that? They can get their poundage fees, they can just issue their levies. And
Well, no,
knowing
counsel,
and willful.
no, counsel, there are consequences. It's just you want a particular judicial forum.
Well,
The question is, which is the proper forum, whether or not there's a particular kind of cause of action. It's not that there are no consequences potentially. That I don't think is a fair framing of the issue. But let me ask you something else. I know your time is short. Should we make a distinction? I know this is in, the Second Circuit mentioned it in passing. It's a little bit in the briefing, at least from the amicus. Should we be making a distinction between let's call it for the moment, wrongful conduct to enforce a debt versus wrongful conduct to enforce a valid judgment? Is that perhaps a better framing of the question as posed?
Well, I'll say in the case of the marshal where you knowingly and willfully execute and exceed your authority, that's a distinction versus, and that's why the sheriff is not in here. The sheriff is not in this case because he served it within his authority. Now, what's the liability on that? It's under CPLR 318. The creditor had the obligation to properly serve that levy. There's only two ways you can serve a levy under the CPLR. You have to serve it on an officer of the company, or you have to do it under a designated agent under 318. Now, Comerica doesn't have a principal place of business in New York. Their principal place of business is in Texas, so they don't have a designated agent under 318. It wasn't served on an officer of the company because they're not here, and therefore this isn't a technical defect. It's a fatal defect because they couldn't possibly serve Comerica with a levy in New York because they have no designated agent under 318. They have no officers in here. So it couldn't be done whatsoever. So that's why it's up to that's why the creditor, the CMS, the MCA that directed the sheriff.
And let me just ask you, given the way you've set out the wrongful conduct, does Article 52 not provide? I understand your point that it's about choice, that you should be able to choose how you wish to proceed given the wrongful conduct. But just to be clear, you're not taking in the position that Article 52 doesn't provide a remedy for the wrongful conduct as you have described it. Is that correct?
Well, all I can say is what happened in Silvercup. Like, so Article 52 can modify a judgment, but modify a levy. It can do that. It can order restitution, which they did. But you have to bring a plenary action. So Article 52 in and of itself is not enough. You can't seek attorney's fees for the damages. You can't seek consequential damages under Article 52. You need an underlying tort action, which is the wrongful execution. So Article 52 in and of itself doesn't do it alone. So you need to go back to the common law and rest on the common law remedies, which are not needed by a plenary action. And in Silvercup, that's exactly what he said. He said,
You
"I'm
mean
gonna
if,
modify it."
you mean if the execution, the wrongful execution has occurred, as opposed to if you're able to preempt the wrongful execution,
Correct.
correct?
Correct.
So you're talking about that smaller class of wrongful conduct.
Correct. And here, I can't say enough that the damages here are clear. There was, let's just use round numbers, $300,000 in the bank account, and then there's then there's not. It's zero. Those are the damages. Now, if they want to say, well, there aren't really cognizable damages because there was a valid judgment, and we're going to use that to collect that's where you have to get into the offset and equities, and that's where you don't get to apply that. A wrongdoer, someone who breaks the law, cannot break into someone's house, take that and say, hey, well, that was mine anyway, now I get to keep it. No, it has to go back. You have to go back and obtain those lawfully. So if that money went back, then it would be back in the bank account, and then they would have to use lawful means to obtain it. And then when they use the lawful means to obtain it, then there was all sorts of the protections that they could go. They could have, the receivership could have stepped in Michigan. There are all sorts of protections that were evaded. And I know I'm running out of time, and I thank you so much for your patience. This is an incredibly important issue. But the law of the state cannot be that you can break the law, collect upon a judgment, and then just say it doesn't matter because there was a lawful judgment. That
Thank you,
can't be the
counsel.
law.
Thank you.
Thank you.